You would like to?
Yes, of course. Hello, everyone. Good afternoon. I'm Manfredi Domina, as Fabrizio and Sofia said. I am CEO and co-founder of Caplera. We are a legal tech startup based in Italy. I'm also a professor at university at LUMSA University here in Italy. In Caplera, what we do, we leverage artificial intelligence to automate and simplify complex legal and documentary workflows. Uh, I'm so sorry about the fact that my background is in law, but my daily work is about building technology that bridges the gap between legal work and operational efficiency. So I work on this intersection between innovation and regulation, focusing mainly on how AI can transform professional industries while navigating the shift in legal frameworks on our digital era. First of all, the talk of the today's talk is the title is the golden algorithm, intellectual property in the age of AI, or this is what Fabrizio asked to me. But first of all, let me start with a small disclaimer. This talk might seem like a legal lecture. It is not. As I said, unfortunately for you, my legal background influences the way I see things. But I find it very useful to use court precedents that, at the end of the day, they are stories to analyze complex problems and to raise questions about the current state of technology. So please bear with me and try to wear my glasses for these 15 minutes. Second disclaimer, I'll also offer you the second disclaimer. My speech today is full of questions and short on answers. The reason is that AI is a very, very new field that is evolving incredibly fast, and the problems we are facing today are still being studied, both from the perspective of the national laws and from scientific point of view. So let's begin with two stories. First story is in New York. We are at Christie's auction house. It is 2018. There is a portrait that they are selling, is a titled Portrait of Edmond de Bellamy. This portrait has been sold for $432,500. But this is very particular portrait. The signature at the bottom right of the frame is not a name, but this is a mathematical formula. This is the loss function of a generative adversarial network. We don't care at all what is a generative adversarial network. But on that day, in 2018, the art market officially welcomed artificial intelligence into mainstream culture. The law has remained so skeptical. The second story is in Indonesia. In 2011, a monkey took a selfie using a wildlife photographer's camera. The legal dispute that followed that situation, the case is named Naruto versus Slater, where Naruto is the name of the monkey, established a pivotal principle in the in the United States, as in Europe. Copyright belongs exclusively to human beings. So copyright law, as we know, is a child of enlightenment and the Industrial Revolution. Copyright is a child of the era of invention, of the era of creation. And it has been founded on the indissoluble bond between the work and the personality of its creator. But what happens when genius is replaced by a statistical calculation of probability regarding the next word or the next pixel? This is AI. Today, We are not just discussing technology, but the resilience of the incentive system upon which our knowledge economy rests. If artificial intelligence can produce infinite content at zero marginal cost, the risk is that copyright, that is born to protect the scarcity of human creation, right, becomes obsolete or a weapon for the concentration of power in the hands of those who own the AI models. Our intellectual property system is fundamentally anthropocentric. From the Berne Convention onwards, copyright has been the legal garment of human personality. Cases like the macaque Naruto have confirmed that. For now, the law does not grant rights to those who do not breathe. But if the machine has no rights, what happens to the value that it produces? So let's make a step back. How AI create? To create an artificial intelligence, first of all, ingest. Need something to learn. This process sparks the first major clash between right holders and tech developers. Europe attempted the early codification through the Directive on Copyright and Digital Single Market, and that is from 2019. And in 2019, in this document, in this regulation document, at Articles 3 and 4, European Union created few mechanisms to understand or let understand how to protect things that are created by technology. The theme is that the right to object in when a right is violated by a machine or a technology must be exercised in a machine-readable manner. Here, law challenges technology. How can a traditional author protect themselves in a digital world moving at petabytes per second? If you don't apply a digital lock, your work is legally trainable. So your work can be submitted to an AI to train that. In the United States, they have a very different model. There is not specific statutory provision like European TDM, but everything hinged on fair use. Fair use is a legal doctrine in the United States that permits the limited use of copyrighted material without acquiring the permission from the rights holder. It acts like we can say is a safety valve to balance the interest of copyright holders with the public interest in the open exchange of ideas. Unlike the European system, which relies on a closed list of specific exceptions, for example, parody, quotation, private copying, fair use is very flexible, open-ended standard, and it's evaluated by judges on case-by-case using four statutory factors. We have four factors of evaluating fair use. First factor is the purpose of and character of the use. Is the use transformative? Does it add something new, or does it merely supersede the original? For example, no-profit educational use are favored over commercial ones. Second factor is nature of the copyrighted work. Using, for example, factual or technical works is more likely to be considered fair than using highly creative works like novels or movies. Third factor is the amount and sustainability of the portion used. More you use and more is essential of that creation, more is probably that the judge will judge these things as not a fair use. So, for example, if you take the heart of the work, even if it is brief, this can weigh against the fair use. Fourth factor is the effect upon the potential market. This is often the most critical factor. If you use something there is inside the fair use, but at a certain point of the life of this new creation, this became a substitute of the original, you are damaging who created the first work. So you are not anymore under the fair use. Now, the fair use is used by big tech like OpenAI or Meta and so on, that training is a transformative use. So what they say is that they are inside the fair use because they are just using information that mainly are public, and they transform this information in output regarding the ask of someone that is prompting an AI. However, the recent Supreme Court ruling in precedent, this Warhol versus Goldsmith in 2023, has shifted the ground. If a derivative work competes in the same market as the original, the fair use does not work. If an AI uses the New York Times photos to provide news that replaces reading newspaper, the defensive shield of AI companies might crumble. So let's dive into the core of doctrine. For a work to be protected, it must to be original. But what does originality mean for example, the Court of Justice of European Union? According to the landmark rulings such as Infopack and Painter, that are two cases that are really, really important, a work must reflect the author's personality, meaning the author must have made free and creative choices. Here, we open to the prompt dilemma. You know that the prompt is the command that we insert inside the chat when we use ChatGPT or other AIs. So, is writing command a sufficient creative act? Most European jurists and the US Copyright Office say no. The prompt is viewed as a commission, not an execution. I'm just asking to create something. I'm not create something. But the user lacks predictive control over the output. So at the end of the day, the machine makes the final aesthetic choices. If I'm asking to create an image, a picture, I'm just asking what the picture have to contain, but the picture, the color of the picture, it will be a cartoon or something like this, that will be chosen by the AI. But while we philosophize about personality, China is really accelerating. There is a case very, very interesting, that is Li versus Liu, cool, in 2023, where a Beijing court recognized copyright for an AI-generated image, arguing that the user, through the selection of different parameters and negative prompts, so do not do this, do not do this, infused intellectual investment into this work, and so the work that has been created by AI has a lot of command, and these commands are enough to be considered as a copyright protected creation. This is not so simple, because what we have to understand is that in China, the government is trying to push the use of AI, the use of internal AI. So also the decision by the court are technically a symptom of the utilitarian view of China. So they are protecting output to incentivize the domestic AI industry. So the judges there are not free as European and US judges. But try to have a different point of view. What happens if an AI work is not protectable? It falls into public domain. So this creates a very, very interesting economic paradox. Will companies like big techs invest billions in models? Because we have also to consider, for example, that these models manage also the, for example, medical devices and so on. So they are not just use of creation of a picture, but there are also synthesizing of proteins and research on cancer and so on. So will companies invest billions in models that produce content that anyone can legally copy? Europe has responded with the AI Act in 2024, at the end of 2024, that is not a copyright law, but it's a safety and transparency law. And they say that providers of general purpose AI models must be publish a summary of the copyright data used for training. This is a formidable weapon for right holders, because for the first time, they will have evidence required to litigate. So if a right has been violated by someone, they have, of course, evidence that what they created has been used by AI to create something else. But we also have another systemic question. At a certain point, we can't ignore to regulate things created by AI. It's a worldwide technology, is used by everyone today, and in a few months or maybe years or maybe days, we will be, of course, the things created by AI will be a lot more than things created by human. So should we create a protection similar to database rights for AI works, for example, with a shorter duration, 1 year, 5 year, something like this, less linked to the personality of the author, of if the market is flooded with zero-cost AI content, maybe will human work become a certified luxury good? Or if an AI produces a work that defames or infringe a trademark, who will be liable? The software creator, the user, or the machine itself? So in conclusion, we are witnessing a genetic mutation of intellectual property. Copyright is shifting from protecting the act of making to protecting the capacity to instruct and select. Humans are no longer necessarily the brush, but they are becoming the director of algorithmic flows. The challenge for future jurists, but for future people that works in technology, will be defining how much humanity is required to justify a legal monopoly over a work. The risk is not that machine will become human, but that the law in chasing technology may end up treating human beings as mere data processors. So thank you so much. It has been a pleasure to be part of this amazing project. I know that I saw you in Bilbao, and I'm so happy to have seen you here. I'm so delighted to be here. Thank you, Fabrizio. Thank you, Sofia. Thank you, all the organizers, for this great opportunity.
Thank you, Manfredi. Thank you so much. I see there is a question in the chat box. The question is, if I create a song with lyrics partially taken from a generative AI, who has the final copyright of the lyrics? Or in education, if a student in a European university uses generative AI for research and submits the paper, who is the owner? There will be a problem with plagiarism. You're muted.
Sorry.
Yeah.
The two situations are, of course, two very different situations. Let's start with the first one, then we go to the second one. First one, song with lyrics partially taken from Gen AI. Gen AI has no rights. And basically, if you are able to demonstrate that the lyrics are, yes, partially taken from Gen AI, but no one knows it, and that you did the second part of lyrics and the music and the harmony and so on, you have to consider the song as a unique part of work, as a unique work. So probably the copyright will be yours till an AI provider understood that your song has part of lyrics taken from that. Maybe no one will never know it because it's absolute impossible. But technically, AI has no rights. The provider of AI has rights, but I think it will not action that right on you. The research, the university research, is a very particular case because technically the training and the use of data for research are basically in Europe available. It's possible to use AI to train and to make research. Also, if you are using data that are protected by copyright or protected from someone. So there won't be a problem of plagiarism, but we have to pay attention if your research became a product that you want to, for example, introduce in a market. In that way, if you made the research using things protected by copyright and you are using the results of that research to make product that you are introducing in a new market or in your market or in generally in a commercial use, there you could have few problems.